Richard Thompson is the president and chief counsel for the Thomas More Law Center, which brought the first case against the Obama compulsory health care bill that passed both houses of Congress despite a large majority of Americans opposing it. The center is now appealing the lower court ruling to the Sixth Circuit. The ramifications of this lawsuit are both widespread and far-reaching. Our guest gained national prominence as prosecuting attorney for his uncompromising stand against Jack Kevorkian, despite public opinion in Michigan, which overwhelmingly supported doctor death and physician-assisted suicide. At the Thomas More Law Center, he directs a highly professional and aggressive team of lawyers dedicated to the defense and promotion of the religious liberty of Christians, time-honored family values, the sanctity of human life, a strong national defense, and an independent and sovereign United States of America. We are very fortunate to have with us, and it is my distinct privilege to welcome Richard Thompson to the Global Freedom Report. Happy holidays, Richard.
Merry Christmas, and thanks for having me, Brent.
And thank you for saying Merry Christmas. Boy, oh boy, I love that.
Well, you know, a lot of times when I go out shopping now, the first thing that a clerk says is Happy Holidays. When I say Merry Christmas, you get a smile on their face, and they say Merry Christmas right back.
There you go. And for anybody out there who might be offended by Merry Christmas, oh well, deal with it.
Right.
You gained prominence as a prosecuting attorney. How and when did you make the shift from prosecutor to defender, and how is it different for you to work on the other side of the aisle, so to speak?
Well, actually, after my stint as the Oakland County prosecuting attorney, in which, as you indicated, Jack Kevorkian began his experiment on physician-assisted suicide, I actually was defeated in a primary, left the office in 1996, and in 1999 started the Thomas More Law Center, which is a public interest law firm, and you quite cogently indicated what our mission was. And from that point on, even though I love the prosecuting attorney's office, I love this job even more. We don't have to get involved with the politics or the partisan politics. We don't have to, find out what is the public opinion polls saying. We just do what we think is the truth and fight for the Christian principles of the sanctity of human life, the traditional family values, and also the religious freedom of Christians. And now we've added, because of the increasing threat of Islamic terrorists in the United States and across the globe, we've added national security and the sovereignty of the United States, because we feel all of this is intertwined. As George Washington said in his farewell address, religion and morality are indispensable supports to political prosperity. And if we want to have a strong United States of America, we have to have a strong religious base, and we have to have a strong system and standard of morality. And I'm concerned that we're losing all of that in the last 20 or 30 years, and it's getting even worse. And
your concerns are well noted and well voiced. I too am very much concerned. I'm just curious whether or not you approach the law any differently as a defender as opposed to a prosecutor. I understand the political aspects of being a prosecutor, and that's part of why I asked the question. For example, you prosecuted Jack Kevorkian. Do you feel any differently about his cause, physician-assisted suicide, now that you are no longer a prosecutor? Does your perspective on the law and the issues change?
Not at all. When I prosecuted Jack Kevorkian, obviously as a prosecuting attorney, an elected official, you're sworn to uphold the constitutions and the law of the state of Michigan. And when Jack Kevorkian first started his experiment of assisted suicide with a woman 52 years old, out of Washington, who came here because she was suffering from the early stages of Alzheimer's, and she still had a quality of life left. Kevorkian, in my view, basically talked her into committing assisted suicide. And I looked at the law at the time, I looked at the facts, and I felt that Kevorkian violated the law of the state of Michigan. It was the common law. but I felt he violated the law, and I charged him with first-degree murder. A court dismissed the charge, saying, well, you can't use the common law. The cases that we were depending on were from the 1920s. There hadn't been a lot of cases on physician-assisted suicide or assisted suicide, period. And so the court said, you can't depend on that. Kevorkian continued to commit these acts of assisted suicide. I think they were basically murders, and we continued to prosecute them, and we'd lose these cases, and the people got upset, saying, you're wasting taxpayer money. But I was concerned that once we allowed a principle of law to become inculcated into Michigan's law, that is, there is such a thing as a life not worthy to be lived, that they would start including more and more people into that category.
Oh, yeah. Now that you are in a position of being a defense attorney, do you view cases such as, such as Kevorkian and whatever else, do you view them from a law perspective any differently, since you're not a prosecutor, or do you just see them similarly and then you apply what you see to your particular role as defender?
Well, first of all, there is a difference. In other words, we are now advocates for, as I said, the Christian point of view. What we look at, though, is the fact that there is a Constitution, and we are interpreting the Constitution as much as we know how in the eyes of the original intent of the founders. And that's where I think a lot of the problems that we are now facing developed when our courts, our activist courts, turned the Constitution on its head, where it was supposed to be a Congress of a federal government of limited powers. They've continually expanded the powers of Congress and limited the freedom of individuals. We had the First Amendment, and we do a lot of First Amendment cases where the First Amendment starts off, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The intent of Congress at that time, and if you just look at the words, the intent of our founding fathers was to prohibit the federal government, to prohibit Congress from establishing a national religion. It was not to prohibit religion at all, but it was to prohibit Congress from establishing a national religion, because several of the states at the time had their own religious incorporated in their constitution, in their laws. But what happened was they took that phrase and they turned it on its head, and now they've interpreted it to mean that there is supposed to be a wall of separation between church and state, phrase nowhere found in the Constitution.
Yeah, we know that one. That's with the letter to the Danbury Baptist Church.
Right. It was a letter of, it was a courtesy letter that Thomas Jefferson sent to the Danbury Baptist Church. But what they've done is, and if you just look at, what's really good, we have a written Constitution, so everyone can read what the powers of government are supposed to be, and what individual powers we have. There is no mention in the Constitution of separation of church and state. The prohibition is addressed to Congress. It is not addressed to states or the school districts or to municipalities.
Or to the people.
And so what we have here is the Supreme Court took that language and took the phrase that Thomas Jefferson used in the Danbury Baptist letter and made it into a metaphor, and that metaphor now is the law of the land. And one of the things that we're trying to do is fight this idea that there must be a separation of church and state, between church and state. The ACLU wants to eliminate all mention of God. They want to banish God from the public square.
So what else is new? Let me ask you on the constitutional issue. I want to ask you a question of legal theory. And then I want to talk to you about this health care law lawsuit, the one that's going up to the Sixth Circuit. But the theory question comes first. If it was found now that Obama was ineligible to be president, that he was not a natural-born citizen, what would happen?
Well, that's a great question because I know people have been struggling with that. I don't have a well thought out legal research conclusion to that, but it would seem to me that they would look at the laws that were passed with his signature as de facto laws that would not be overturned. I think I think the courts would craft some kind of theory that would not throw everything into chaos. So, on the one hand, you could have, let's say, Obamacare being thrown out because he signed it, but there would be hundreds of bills that would have to be thrown out, hundreds of executive orders, et cetera, that would have to be thrown out. So I don't think the courts would go as far as to say everything that Obama did was then illegal and for naught. I think they would draft some kind of a legal opinion that it would allow it to stand.
That is really, it's unfortunate that you're probably right, and that's really unfortunate because what it says is the convenience and the maintaining of order is more important than honoring the rule of law. Well,
we have, as you look at it, and I haven't been following it that closely because of all the other things we've been doing, but you've had several people challenge the fact that Obama is not born in the United States that would give him the right to become president. And yet, all of those cases are being thrown out on technical reasons. No one has been able to really get to the substance of the issues. And
which is why it's a question of theory.
Right. Well, and that's sad because in the beginning there should have been some kind of a certification that he in fact was natural born in the United States, but that never was done, and they have never shown the actual birth certificate, and that's what causes a lot of people concern. They want to see the actual birth certificate, and I don't understand why they would not end all of this, controversy by just saying, okay, here's the natural.
Well, and the easy answer is because he's not a natural-born citizen, so he can't.
That would be one of them.
Obviously. All right, let's talk about this health care lawsuit because we only have about 15 minutes or so, and I got a lot of questions here. First, what is the current status of your appeal to the Sixth Circuit in the lawsuit regarding the Obama health care?
Well, we just filed our opening brief last week, and now the federal government will have to respond. And as you may know, we were the first in the nation to file a lawsuit on behalf of the Thomas More Law Center and 4 individuals. The district court judge in Michigan that heard the case dismissed the case on what is called summary judgment on the grounds that it still was authorized under the Commerce. Obamacare was still authorized under the Commerce Clause because not only did the Commerce Clause include economic action, but it also included economic decisions and thought. And it was good for us in the sense that it created the issue that we wanted to take up to the United States Supreme Court, and that's where we're headed. We know that whoever lost the case at the lower level, whether it would have been us or the federal government, would then appeal to the Sixth Circuit, and then from the Sixth Circuit, it would go up to the Supreme Court.
And before we get to the Supremes, because I have a couple of questions on this procedurally. And obviously, I mean, if the government can decide on what your decisions are based on the Commerce Clause, then we are slaves in the so-called land of the free. There was another case.
That's the concern. Yeah, that's the concern. It would totally destroy any idea of limited government.
Yeah, exactly. Now, there was a second case, this one in Virginia, in which the judge also ruled that the compulsory coverage provisions of Obamacare are constitutional. Do you happen to know the judge's rationale in that case? Was it the same?
Well, that are unconstitutional.
No, there are two. There are two in Virginia. There is one case in Virginia in one district court that ruled the same as your Michigan case. Then there is a more recent case in which the district court ruled that the coverage requirements are unconstitutional. So we have two out of Virginia.
Okay, I'm not sure. I'm not familiar with the one that held it unconstitutional.
Okay. Nope.
I'm familiar with a more recent one that came out and where the judge said that it is unconstitutional.
It is unconstitutional. Okay. Now, how does that affect your appeal? Does it help?
It helps because the basis, the logic that the judge used is the same logic that we were using. That you cannot have such a broad interpretation of the Commerce Clause that it would include a person who has taken no action at all, who has not made any kind of economic decision that has been interpreted into action to then submit to the Commerce Clause. What this would do, it would compel an unwilling person to perform an involuntary act, and as a result, submit to the Commerce Clause regulation. And the court said you can't do that, and that's what the individual mandate required. Either you submit and get insurance, or if you don't submit and get insurance, you are then fined. You pay a penalty. And that basically produces the revenue that the government is going to use to cover all these other individuals who do not have insurance.
Correct. Now, you have suggested, though, that the Virginia case, the one that ruled it unconstitutional, that could somehow help you. Does the appeals circuit...
No, I misspoke myself. The Virginia case that held it constitutional would help us. The judge's decision, Judge Hudson's decision, will help us.
No, wait, there's two cases. There's the one that held it to be constitutional.
That's the one I was referring to.
That one, okay.
Okay.
All right, then there's the second one more recently that held it to be unconstitutional. So we actually have two out of Virginia.
Okay, let's get, let's make sure that our audience understands. There is a case of the Commonwealth of Virginia brought by the Attorney General against Kathleen Sebelius. That case held that the Obamacare is unconstitutional. That case is the one that helps our case as well.
Now it does, because I was not I didn't know that the appeal circuit actually considers the reasons given from the district court when they evaluate. Do they?
Oh yes, they will use the arguments. Of course, they don't have to follow them religiously, but they will use the arguments that the district courts made. Of course, they can disagree with them, but the district courts have already analyzed all of these positions, both the government side and also the Attorney General side, the state of Virginia side, and they came out in favor of the state of Virginia, saying that Obamacare is unconstitutional. It's gone too far. It's exceeded the boundaries of the Commerce Clause, and that's the important aspect of the case. The Congress and President Obama said that they were enacting Obamacare under the authority of the Commerce Clause, and the courts are now looking at that under the authority of the Commerce Clause, and they're saying that the Commerce Clause does not allow for that kind of legislation because it is not connected with economic activity at all. It basically is penalizing someone for not taking any action, for not making any decisions, right, for not engaging in any kind of economic activity. And usually the courts have always indicated that for the Commerce Clause to apply, there has to be economic activity involved. So,
well, I am reminded of Judge Andrew Napolitano once told me of the case, I think it's out of the 50s, in New York, where they decided that the Commerce Clause applied because it had to do with construction workers working on skyscrapers, And they said when these people work on skyscrapers, they could see across the Hudson to New Jersey. That makes it interstate. Therefore, the Commerce Clause applies.
Well, here, normally now, under the traditional Commerce Clause jurisprudence, you have to have, there's three things that you can have that would fall into the Commerce Clause. One is that Congress can regulate the channels of interstate commerce. Secondly, Congress can regulate the instrumentalities of interstate commerce in persons or things. And then third, Congress has the power to regulate activities that substantially affect interstate commerce. Well, a person sitting in his house doing nothing does not fall within any of those three categories.
Well, but forgive me, Congress has been known to make arguments like if everybody sat in their house and did nothing, it would shut down the economy. That's a kind of argument they have to make. The aggregate of all inactivity somehow affects interstate commerce. But if you use that logic, then how is a person ever protected from the powers of Congress? Exactly.
Because if I exist and do nothing, they might say in regards to any issue that now you've affected the aggregate of your actions affect interstate commerce. Yeah. And that's what the big concern is. It is a matter of liberty, and it's a matter of using such an expansive interpretation of the Commerce Clause that we no longer have a limited form of government. We basically have tyranny by Congress.
Yours is the first appeal on this particular legal matter. Now, if the Sixth Circuit decides the lower court erred, can it declare the relevant parts of Obamacare unconstitutional, or does it have to remand it back to the lower court for further hearings?
No, because it is a legal question, they can answer the legal question and say, based upon, our interpretation of the Commerce Clause, therefore, the act itself is unconstitutional, and they strike down the provision that contains the minimum mandated activity.
Now, if they can,
what then the federal government will do, obviously, is then they'll appeal it to the United States Supreme Court.
Now, the Supreme Court, however, can choose to take it or not, if I understand correctly, until the Supremes take the case. Am I not correct that being that the Sixth Circuit would be the sole appeal circuit ruling on the issue, that would become the case law? Isn't that? Do I have that right?
Well, it would become the case law in the states that are covered by the Sixth Circuit Court of Appeals. Now, you also have other cases going up. Now, the Virginia case would go up. You might have a different Court of Appeals decision in Virginia.
But until you have that, pardon me, until you have that differing, until the whole process, they go through the whole process and get a different appeal circuit ruling, doesn't it stay out of the Supreme Court? Doesn't the Supreme Court only come in when you have differing rulings on the appeal circuit?
Well, the Supreme Court comes in once one of the parties files a writ of certiorari that is requesting the Supreme Court to review. At that point, the Supreme Court can review the Sixth Circuit Court of Appeals decision, or it can say we don't want to review it until other courts have ruled on it as well. Many times when you have differing opinions by different circuit courts of appeal, that's when the Supreme Court will take it up. But I believe that the first case gets up to the Supreme Court will be heard by the Supreme Court because it's such an important issue. It involves, 1/6 of the nation's economy and billions of dollars in funds. So it will be heard. Now, whether our case goes up, I think it's a good chance our case will be finished in the Court of Appeals before any others. But it really depends on how fast the various judges move.
Now, would you wager, would you make an expectation on when the matter would end up, or if it would end up with the Supremes? And if so, for bonus points, would you even venture an opinion on how you think they would rule?
Well, I think they will rule in our favor. I think they will hold the individual mandate of the Obamacare unconstitutional because, as we indicated, it would be a total destruction of any kind of limitation on the Commerce Clause powers of Congress. There are two cases going up now. The Virginia case is going up, and we're going up. It really depends on how fast each of the circuits work. Now, we've already filed our brief. The federal government has 60 days within which to file a reply. Then the case is set for oral argument. It depends on exactly at what point the Sixth Circuit judges set it up for oral argument. There are a lot of, various, as you know, there are a lot of different techniques that can be used to stall by the government if they want to, or there can be an expedited review. I think both parties believe that an expedited review is in the best interest of the citizens and of the government, in fact, so they know where they stand with reference to the rest of Obamacare.
Now, it has been said from many sources that the compulsory coverage provision doesn't get implemented until 2014, so that we don't have to worry about this for several years. Is it possible that these cases will get delayed substantially? And if so, will that give Obamacare an opportunity to entrench itself in society? Also, if this is found unconstitutional ultimately, does it completely dismantle Obamacare, or do we still have to deal with that?
Well, to answer your last question first, if the individual mandate is thrown out as unconstitutional, the rest of the structure collapses because the Obama administration depended upon the funding, the penalties that would come from these individuals who are not insured to fund the rest of the uninsured people. Now, what was your first part of the question?
Actually, I forgot. It's all right.
Yeah,
we're out of time, Richard. We really are.
Okay.
But I appreciate so much you're giving such clarity to these otherwise very complex issues. My guest has been Richard Thompson, President and Chief Counsel for the Thomas More Law Center. If you'd like to get more information about the work they do and support what they're doing in defense of your religious freedoms, www.thomasmore.org. Now, More is M-O-R-E, thomasmore.org. Richard, thank you so much for being with us here on the Global Freedom Report. The best of fortune and success in everything you're doing.
Thank you, Brett. Again, Merry Christmas to you and your audience.
And Merry Christmas and Happy New Year to you, too, and to yours. Richard Thompson, the Thomas More Law Center.